How excited are you guys? Are you as excited as I am for eviction hour? This is some of the best advice you're going to get out there from the best eviction attorneys in Southern California. And we got a lot to cover today. And this is for renters and landlords. We're just trying to help people do the right thing. So, the very first thing we're going to do is let's bring the guys in ties in. So, get our round of applause ready. Kenny, you're first. Yep. And he's wearing a tie today. That's good. Zach, welcome. Appreciate it. So the guys in ties can actually give tax or legal advice. I'm going to say a bunch of stuff, but at the end of the day, it's not tax or legal advice. So we're going to talk about a bunch of stuff. LA City right-to-counsel. We're going to talk about that. We're going to talk about SB 79, security deposit questions. LA City's looking to change rents. Well, I mean, there's so much to cover, you guys. I don't even think we can do this. You guys set aside 3 hours for tonight, right? You're good with that?
We try.
We got to talk about the new cooling law in LA County. And then what else were we going to talk about? Oh, how about this one? The LA County rent gouging protection was extended. Did you guys know that? Of course you knew that. You're just showing off now. Yeah, so it was extended for another 30 days. So it is now set to expire October 29th, 2025. So that was extended. So just bear that in mind that you cannot increase rents more than 10%. And that includes if you're bringing it to the market, if you've never had it on the market or it's been a while since it's on the market. So how's it going, guys?
It's good. It's good. Just chugging through, trying to figure out what exactly LA City or LA County or the state of California is doing. It's always kind of a grind to figure out what the next step is going to be with them.
Exactly. Look, Bug is excited to be here, but Bug is in NorCal. Some of the stuff we're going to talk about is going to definitely apply in NorCal as well, Bug. So thanks for coming out. So one of the first things I wanted to do with you guys is I actually created an eviction flowchart. So let me get this thing up. I want you guys to look at it. There, it's nice and tiny. Let's zoom in on that. Hopefully we can do this. Get zoomed in. It doesn't look like it. That's great. I love technology. So anyway, so not that anybody can actually read our eviction flow chart, but let's go through it. And Kenny, I want you to correct me where I'm wrong. Zach, I want you to step in. So what I broke it down into is the no fault versus at fault. So Zach, tell me the difference between a no fault eviction versus an at fault eviction.
Yeah, so they're based on whether or not the tenant did something wrong. So that's the fault, right? So if, let's say it was based on non-payment of rent, a breach of the rental agreement, or the tenant's committing some kind of nuisance, then those would be at-fault notices. Typically, those are shorter in length, and they usually give the tenant an opportunity to cure. There's also no relocation assistance required.
Oh, yeah, good point. Yeah.
For no fault notices, those are where there's no fault alleged on the part of the tenant. And notice that that doesn't mean that the tenant has never done anything wrong. It just means that the reason that they're being evicted doesn't depend on that they did something wrong. So I have landlords all the time who say, I want to do an owner move-in eviction, and they characterize it as no fault, a 60-day notice. But they said, but the tenant has lots of faults. The tenant's, annoying. It doesn't clean up after themselves.
That's not nice. We all have faults. None
There
of
you
us
go.
are
Very
perfect.
Merry Yom Kippur to everybody who's Jewish who's listening. I'm not a temple either, so don't worry. But yeah, we all have faults.
Yeah, thank
We
you,
all
by
have
the way,
faults.
for that. Yeah.
And so if the reason for the eviction is not based on the fault of the tenant, then typically it's a longer notice, and there's going to be potentially some relocation assistance implicated as well.
And then, so what I broke it down here, and again, this is me doing this, the guy who can't give legal advice, so you guys call me out. So what's important for people to understand, the eviction process starts with the proper notice. And just as Zach broke it down, it's either at fault or no fault. If the tenant moves out after being given proper notice or even improper notice, that's it. It's over. You don't move to an unlawful detainer, because unlawful detainer is about getting possession of the property.
Yeah,
Correct?
exactly. So one of the elements that when you do trials, one of the elements that the landlord has to assert is that the tenant is still in possession. And I've seen some judges be very sticky about that situation where if you don't ask that question, even though it's very obvious, they'll sometimes say, well, I can't give you judgment for possession because that's not an issue. Just a little funny thing that some judges will do.
Yeah, it makes sense. This is in the event that the tenant does not move out. Then the unlawful detainer will be filed. So it's a complaint and a summons, two separate pieces of paperwork. And landlords, let me tell you, do not do this on your own. In fact, don't even give a no fault or at fault notice on your own. Hire a California property law group to do it, because one of the most common things I see is that the wrong notice was given, or they couldn't give a notice, or they didn't deliver the notice properly. What do you guys see? Is that one of the most common mistakes that you guys see, is the
The
noticing, or
notice
Yes.
is,
beyond that?
oh, go ahead, Kenny.
Yes, so the notice is what predicates and starts the eviction, and you can't change that in the middle of litigation. We've seen many landlords who have done their own notice and realized during the litigation that they're overmatched, or the other side has an attorney now and they don't know how to push the case forward. Even if you were to hire, say, us or another attorney, we cannot fix the notice at that point. If the notice is defective, the notice is defective. You can't go back and amend it. You can't go back and change it. Just like as a comment that Zach had mentioned before, um, deciding on if you do a no fault or an at fault. If you decide to do a no fault and then you want to also bring up at trial, well, the tenant has a lot of issues, a lot of at fault reasons. That's not going to be relevant to your case because the notice that you served was the no fault notice. So you have to be very particular and careful about which notices you serve so that you know what you're going to say at a trial in the event your case goes to trial.
And then once the paperwork is properly filled out by a California property law group, how is it delivered? You guys use a process server, correct?
Yeah, that's correct. So the difference between a process server and everybody else in the world is that the declaration of a registered process server carries more weight than the declaration of someone who's not a registered process server. So that's essentially the job of process servers, is to give people legal documents. Additionally, there are many, many different laws which govern how and when you give legal documents, and the process servers are trained on how and when to do that. So it's another reason that I don't recommend that people do it themselves, both because they're losing a possible advantage. Having a registered process server means that their word is going to be given more, let's say, weight than someone who's not a registered process server. And on top of that, it's very likely that a person who would otherwise be serving the documents would make a mistake. And just as with the notice, any kind of mistake can either delay the case or cause you to lose the case.
And then from there, once the paperwork is delivered, the tenant now has 10 court days to respond, which is new this year. Used to be 5 court days, but now they have 10 court days. And what's a court day, Kenny? What does that mean?
It's any judicial or it's any court day, really. It's any weekday that's not a court holiday. If you go to the court's website, they have a list of what the court holidays are, and obviously you don't count weekends. So you're going to have to pull out a calendar to see when the date of the last response date would be, and you have to also add in time for service. So depending on if you were to give the tenants the lawsuit personally, if you were to give it to them by subservice, by substituted service, or by order to post, which is you post it and mail it, that can add on additional days beyond the 10 days.
And then if the tenant doesn't respond to the unlawful detainer, so you still have to wait your 10 court days. As a landlord, you have to wait to get the response from the renter. So that's adding time to the process. If they don't respond, then the landlord is able to go and enter a default judgment. What does that mean?
So a default judgment means that you win the case because the other side didn't appear. So they admit all of the allegations that are in your complaint and you win the case by default. Essentially, like if I was going to play LeBron James in basketball and and pick up 1v1. The only way that I would ever win is if LeBron James just didn't show up and I could just shoot on an empty rim. And even then,
Are you sure? You could have a really good day, Zach, and LeBron could have a really bad day. So I
I would
wouldn't
hate to
go.
find out. I would hate to find out because even a bad day from him is better than the best day I've ever had. So, but if the other side doesn't show up, it doesn't necessarily mean that you'll win 100% of the time. It should be noted that you'll still have to show the court that you basically are entitled to what you're asking for. So if you made any of those paperwork mistakes that we had mentioned earlier, it's possible that the judge will still not let you get default judgment if, for example, you failed to serve the correct notice, failed to attach the notice to the complaint, or made some other kinds of paperwork mistakes. So avoiding those paperwork mistakes means you won't get hung up on this stage of the process. There's two different kinds of defaults. There's going to be a judgment for just possession, and then there's going to be a money judgment, right? Essentially, after you, skipping ahead a little bit, but if you, when you get possession of the property back, you can go back to court and ask them for a money judgment to make up for the time that the tenant was unlawfully detaining your property. You don't have to do that right away. You can essentially file for a judgment that's just for possession, get your property back, and then go and get a money judgment.
So that was a great piece of advice. And you also explained what unlawful detaining is. It's the renter is unlawfully detaining the property. So that's good to know that that's what that means. So in the event that the default judgment goes in favor of the landlord, then they can get the writ of possession. The sheriff will give the notice to the tenant, and then there's going to be the lockout. Correct?
That's right. Yeah. So a writ of possession is an instruction to the sheriff to do a particular action. So because you won the case with the default judgment or with any kind of judgment, now you can get a writ, and the writ instructs the sheriff to do something. So in this case, the writ is going to instruct the sheriff to restore the landlord to possession of the property. There are other kinds of writs, and I'm not going to go into like kind of the medieval stuff, but there are other things that the sheriff can do. But after an eviction case, typically what you're going to get is a writ of possession to get real property back. There are other kinds of writs that will allow you to go after, for example, money damages, to do bank levies or wage garnishments, things like that. But just focusing on unlawful detainers, they pretty much always end, if they end in the landlord's favor, they end with a writ of possession.
I just recently did a sheriff lockout for a client of yours that we were working together with. So it was interesting. Nice guys. Sheriff showed up and basically knocked on the door. There were some folks there who had no idea what was going on. Explained to them, got them out of there. Went through the house with their guns drawn to make sure it was safe. And then at the same time, I had a locksmith there and changed all the locks. It was there were like 18 or 20 locks through the house, maybe even more. It was crazy. We were there for hours changing locks. But okay, so that's in the event that there's no response. Let's go back up here. So in the event that the renter does respond, it looks like there's three possible paths. And we'll move this fast because I know you guys do this all the time. You're bored talking about it. But the three possible paths is they just file an answer, or they could file a demur or motion to strike, or the tenant can file a motion to quash the summons. So, Kenny, dive in and tell me what those mean. What's a demur or
Yeah,
motion
so
to
these are
strike?
all what's known as pleadings, but they basically, the motion to quash summons basically says that they weren't served the lawsuit correctly, or there's a defect in the
Okay.
process of service of the summons. And there's different types of those, but generally speaking, as long as you get a registered process server to properly serve the lawsuit, you'll be good to go. But the thing of it is that everyone has the right to make that motion, even if it's what some people will call meritless. Some people can still, anyone can still make that motion, and the court will either deny or grant that motion. Same thing with,
Yeah, that's the hearing. It goes to a hearing with the judge to determine whether these motions are
yeah,
valid,
and
correct?
the California legislature, for better or worse, they did something that I don't know if they understood what they did really, which is they sped up these types of hearings to be heard on a much shorter timeline. Um, it's done a couple of things. Number one is that it's actually, in a sense, sped up eviction cases where people used to file demurs that were set out for 3 months, 4 months, and you just wait for 3 months and being like, okay, well, I got to wait for this. Or you can advance it, but that's a separate motion. But what the legislature did is that they said that these things are going to be heard in 5 days. Now, the problem to a certain degree with something being heard in 5 days is, will the parties that are supposed to appear, either the landlord or the tenant, will they know to appear in 5 days? 5 days is very fast for a court to do anything. So there's a lot of times where you'll see a demur, you'll see a motion to quash, and sometimes nobody shows up because nobody got proper notice to actually show up at all. But we have a system where we do catch these motions. We do check in with the court regularly. So even if we weren't given notice or proper notice of these hearings, we will show up to the hearings to actually defend them.
We've got a message from All Nighter. He wants us to smoke that like button like Cheech and Chong. So he'd be hitting that like button. All right. So let's say that the hearing with the judge, if the tenant wins the hearing with the judge over those motions, then that's it. It's over. You have to refile from the very beginning. If the tenant loses, they're able to file an answer to the original unlawful detainer. So let's talk about filing an answer to the unlawful detainer. What does that look like, Zach?
So there's essentially a checkbox answer that pretty much everybody files that's prepared by the judicial counsel, and then there are additional supplements for that answer that you can find from various legal aid organizations. Technically speaking, you're supposed to plead your answer with the same specificity as you would plead a complaint, but that is rarely, if ever, enforced in unlawful detainer actions. So usually there's just a bunch of checkboxes where the tenant will, or whoever's assisting the tenant will check the box. Now, I see a lot of people who will maybe put too much weight on those checkboxes. Those checkboxes, because it's at the beginning of the case, most of those checkboxes tend to not materialize. So they'll make accusations that the landlord harassed the tenant, and the landlord will be incensed and will say, I never harassed the tenant. You can see that it's very easy to check a box as compared to proving something at trial. So a lot of tenants will check a lot of boxes. I've seen hundreds of tenants check the box that says the landlord violated the implied covenant of good faith and fair dealing. I don't think I've ever met a tenant who could tell me what that means, but they checked the box, okay?
Check that box.
So, just because something is checked doesn't mean you should be worried about it. It just means you should be thinking about it.
And in this answer, is this also when the tenant is able to request the jury trial, or does that come later?
So that can come as late as 5 days before the date set for trial. So you really want to make a jury demand as early as possible to let everybody know that you're looking for a jury trial. Then you have a second step, which is to pay the fees, whether that's by actually fishing money out of your pocket and paying it to the court, or by qualifying for a fee waiver. Either way, you need to address the issue with the fees. And if you've timely demanded a jury trial and you've paid the fees, then you are entitled to a jury trial. So that's all laid out in Civil Code 631. But basically, at the time that you file the answer, it's a very common time to see tenants or just people in general demanding a jury trial.
And of course, you'd know the civil code. I love that about you, Zach. So basically, the memorandum to set for trial, so that gets the trial date. There's mediation or a settlement conference before the trial, correct? Zach, go ahead and fill in.
Oh, you can. So it's not, let's say, in every case. I think that typically judges will they'll assess whether or not the parties have the a possibility of settling. Technically, every case you're required to sign up for what's called ODR, online dispute resolution. So you can conduct informal settlement resolutions prior to the trial date, as well as I believe every plaintiff is required to reach out to the other side to initiate settlement discussions in addition to initiating ODR. But sometimes these kinds of informal or let's say impersonal settlement discussions aren't conducive to settlement, and so the judge can order a mandatory in-person settlement conference. And so that's going to depend on whether or not, essentially whether or not the parties, potentially could come to some kind of agreement. There have been cases that I've been a part of and that I've seen where essentially the parties, they're never going to be able to settle. But for most people, most of the time, if they keep an open mind, they will be, pretty shocked at how much people can move, how much people can come around.
All right, Kenny, tell me day of the trial. What does that look like? And we're back live just as Zach's taking a big old gulp. Day of the trial. Tell me what happens
Yeah.
there.
So
Are you nervous? Are you excited? How are you personally on the day of the trial? And then tell me about the day
yeah.
of the
So
trial.
because of the speed of unlawful detainer, the trial dates, you generally get a trial date within about 20 days. That may not seem fast to most folks, but in the sense of litigation, that is lightning fast. Most cases in regular civil cases outside of unlawful detainer, they'll take about 2, 3, 4 years to resolve themselves. It's a blessing if you were to resolve those cases in a year. So generally speaking, on the day of trial, most of the cases are going to be trying to see whether or not settlement is on the table or not on the table. And the courts will generally defer to the parties to say either settle the case out or come back and do the trial. And then you'll have to either announce ready for the bench trial or the jury trial. I do want to make a point that many cases do end up settling. Very few cases end up going to trial because generally it makes more sense to settle the case out versus litigating it out at trial, namely because of the risks that are inherent on both sides. There's the risk of losing the case for the landlord and having to start the case over and incurring further costs and fees and damages. And on the tenant side, there's a risk of having the case unsealed, owing monetary damages, and having to be forcibly evicted from the property without certainty. So settlement generally is preferred from both sides, and it's usually pushed by the courts as well as many attorneys. So on the day of trial, you just have to make
Yeah.
sure that you're ready in the back to go do the trial, because I know many attorneys out there who aren't ready or who aren't willing to do the trial. And if you don't have that in your pocket, you're not going to get the best settlement terms, if you will, because they know that you won't do the trial. Because if they're not going to give you a reasonable offer to settle the case out, you have to be ready to do the trial. Um, there's no other way around it. And if you start forming either a reputation or it looks like you cannot do the trial, they're going to pull your chain. They're not going to give you anything, and it's just going to be a waste of your time. So you need to make sure that on the day of trial, you have your trial documents, whether it be your witness list, exhibit list. If it's a jury trial, your jury trial binder. All of those documents have to be prepared before the trial itself. And it's a large undertaking for a jury trial.
That's yeah, I remember Raphael telling stories about actually settling outside the courtroom before it started. Like you can actually be working on a settlement right in the hallway before it starts. It'd be interesting. I'd love to know what your reputations are. Are you guys known as bulldogs in the courtroom? I'm gonna guess you are. You guys are good. So, assuming that it isn't settled outside the courtroom and the tenant loses without any sort of interesting settlement, then it goes down the path of writ of possession, share of notice, and a lockout. Correct?
Yeah, that's the same as if basically once you have a judgment in your favor, from that point, all the roads moving forward are the same, with the notable exception that when you do, let's say, a trial, you won't be able to come back and request that money damages later on. So remember that with the default judgment, you could get a judgment for possession only and then come back and get a money judgment later. When you have a trial, it adjudicates all the issues. So money and possession are all wrapped up into one.
Oh, that's good to know. And then, in the event that the tenant wins, which doesn't happen with you guys there representing the landlord, so the tenant would basically be able to stay in possession as long as they pay any back rent that's owed within 5 days or some other deal is they strike, and then the tenant would get attorney's fees. So that's why you guys are always talking about capping attorney's fees. in the lease.
Yeah, so the
correct?
general rule in the States is that everyone pays for their own attorneys. But because many people use kind of form contracts, you can contract your way out of that default rule. So if you have a contract, which a lease agreement is a contract, you can put in that contract the losing party in any litigation is going to have to cough up the attorney's fees for the prevailing party. And that's been a pretty much a mainstay for many of the car forms, many of the AOA forms, many of those lease agreements that people will use in many of these residential lease agreements. And based upon what our experience has been seeing, we have been seeing that to backfire quite tremendously to many, many landlords, mainly because unlawful detainer actions or evictions are very technical and they're very procedural. And a landlord could lose a case on very technical grounds and have to start the case over. Now, losing on a procedural ground or losing on a substantive ground, or saying that you didn't have enough to meet your burden, or losing off of paperwork, like Zach was mentioning, just losing off paperwork, that's losing all the same. And what that means is that you then owe the other side's attorney's fees. I've had some individuals have an interesting take where if they lose on a procedural ground, they didn't really lose the case because they're still right. Um, in my opinion, losing off a procedural ground is still losing. Um,
Ricky Bobby said it best: if you're not first, you're last. That's it. Doesn't matter how come you're not first, you're last. And then it turns out his dad never said that. But anyway,
So
um,
yeah, so it's very dangerous. In our experience, it's very dangerous to have an uncapped attorney fee provision
yeah.
because most of the time, um, there's a very clear idea of where you can attach attorney's fees to. Individuals or tenants that are being sued for eviction because of non-payment of rent, the likelihood is that you're not going to be able to collect on them because they're what's called judgment proof, which is if there's no money there, then you're not going to be able to get that money judgment to actually get your money back. Whereas landlords, you're more or less professing a very enticing asset right there for other attorneys to look at and say, I wonder if I can collect on this. Well, there's a house that you're fighting over that the landlord is asserting ownership over. So it's very clear that there's something to attach a money judgment towards. So most of the times we usually recommend that you remove those attorney fee provisions.
And here's one way to do that. The California Property Law Group website actually has a form, 827 no attorney fees, and in addition, a bunch of other great forms. So there's a little plug for you guys on that. So you would use basically 30-day change in terms of tenancy with that 827 form and change up the attorney fees, either put $0 or $500, something small. Okay, we're going to dive into a few questions, and then we got a lot more to cover. One quick question. How about, so it took us about 20 some odd minutes to run through that flow chart. How long does it take to evict? How many months from, assuming kind of worst case where you have to go all the way through to the sheriff's lockout and there was a jury trial? How long would that whole thing take?
The bulk of it, actually, surprisingly enough, is the sheriff's department.
Mhm.
They'll take anywhere from about 2 to 4 months to actually go and conduct a lockout. The 5-day notice that they post up, it's a well-known secret in our industry. The 5-day notice that sheriffs post up, it's not 5 days. It's not 10 days. It could be anywhere after 5 days, which means it could also be 6 months. So essentially, on average, if you're looking at an eviction case, to the point of judgment, you're probably looking at anywhere between 2 to 3 months. And then the sheriff will add on literally half of that again, which could be 2 to 3 months, if not 4 months. So in total, maybe about 4, maybe 6 months.
Got it. Well, I appreciate that. Yeah. And you guys have given good advice. Don't bug the sheriff. You'll go back to the bottom of the pile if you bug the sheriff. And again, I did a lockout recently with some clients that you guys were helping. And it was, I mean, not nice. Nice isn't the right word for it, but it was cordial and well run, and everybody was professional, even the renters. And that explains why they didn't know about it, because these were not the primary renters. These were like some guys that were just kind of staying there. they obviously, that form, the 5-day notice, must have come many months before, and that's why they didn't know about it. Because I was wondering too why they seemed so confused the sheriff was there, but that explains it. Okay, so Johnny Cash needs some help. One night, the building manager was intoxicated, tried to enter a tenant's apartment. He then physically assaulted the tenant. Police came, but the tenant didn't press charges. Okay. And though there's an incident report for battery. So Johnny Cash wants to know. The manager has a history with the police, has been to jail several times. The tenant now plans to sue. How much could I lose? Will my insurance cover this? So, Johnny, we've had similar questions to this, and this falls slightly outside of eviction law. But, Zach, I think you can take a stab at answering this one.
Yeah. So, I mean, quantifying exposure is really difficult. I mean, so, that's going to be really in the nitty gritty of the facts. I mean, you have an element of potentially physical harm, you have emotional harm, you can have punitive damages involved, because if it's willful or intentional conduct that you want to deter in the future. So yeah, it'd be very difficult to try and estimate the actual amount of the damages. I mean, I would say that, that a lot of the damages are going to be sort of soft figures, and those are going to depend on the victim, let's say. So, essentially, if it really ruined their life, and they can't eat and they can't sleep and this and that, then you have, let's say, more damages compared to somebody who it didn't seem to bother them at all, and were sort of shaken up by it, but moved on. Then, as to insurance covering it, you have different kinds of pieces here that could potentially be in play. Insurance can't cover you for criminal acts or for intentional acts. But you could have, let's say, a negligent hiring claim. There are certain kinds of insurance that would cover you for that. Likewise, for respondeat superior, there are certain kinds of insurance that I think would cover that. I don't necessarily know that your run-of-the-mill homeowners insurance would, but that's something where I would tender a claim to them. I think that's a very good idea, and then put the ball in their court just to see if you have coverage or not. Because doing it yourself is a somewhat daunting prospect.
And again, like Kenny mentioned, that unlawful detainers is that process is a speedier process. This is not going to fall in that speedy process. This will be a long, drawn out thing. All nighter. Thanks for stepping in and giving some advice to Johnny. And then Johnny followed up and says that 9 tenants are also suing him for harassment. So unfortunately, it's adding more pain. So that's an extra layer to this.
And just adding on to that as well.
Yeah.
I think that landlords nowadays really need to get on board with not treating this as a side project, not treating this as kind of, well, I fell into it and let's try to see what goes on here. The state of California, LA, whatever jurisdiction you're in, they're treating everybody as if they know every single law that's passing through here. And so as a landlord, if you keep good records of what you're doing to making sure that you're not in breach of any of your duties that you owe to your tenants that you're renting out properties to, that's going to be the best protection for yourself. And that's going to actually minimize damage, any damages that you may incur towards any lawsuits or any other kinds of incidents that happen. Because usually speaking, the party that is prepared in litigation is the party that's going to prevail.
Well said. And that's for unlawful detainer. That's why you hire these guys, because then you're prepared. All right. So good question from Nick. Is there a grace period after the tenant does not pay before you can file a 3-day pay or quit? So in the rental agreement, so the standard California Association of Rental Agreement, it does reference a grace period, and the default is 5 days. So you look at the lease. What if the lease doesn't have a grace period? What do you guys say?
No, so there's not. You do want to make sure that you're giving them at least 1 business day to make the payment. So if the rent is due by the 1st and the 1st happens to fall on a Saturday, You give them that Monday if that Monday's not a holiday, and then on that Tuesday you could serve them with a 3 to
That's good
10.
advice. Yeah, very good point.
Yeah.
Yeah, there's no reason to rush it. I mean, look, the complete other end of the spectrum are people who give months and months and months to their renters, but giving them a few extra days at this point would not necessarily be a bad idea before filing the 3-day paraquat. But the 800 number for these guys is down here. So call these guys and talk to them. Don't listen to me. All right.
Yeah, and just to add on to that as well, that car contract, by default, it gives a grace period. So
Yeah.
if you as a landlord weren't intending on doing that, you need to actually read what you're giving people. And by default, it does give that grace period. And some landlords are saying, well, I never would have agreed to that. But you're the one offering the lease. You're the one offering the contract. You need to make sure that you understand what you're signing. And just a funny tidbit, this, and I don't know if it's like a thing with the Association of Realtors and their attorneys up there, but with the AB 1482 exemption, and I see this so often, they do it where it's an opt-in on the contract, where
Yeah.
when many small landlords are saying, hey, I need to give this exemption notice to my tenants, saying that this state law AB 1482, I'm not subject to it, I'm actually exempt. On the form, many landlords will never check mark that box that says we're exempt. And then when we get it and we say, hey, did you give this notice? They say, oh, I gave them this form. And then I see that check mark box being uncheck marked. Well, what the landlord did is basically told them, here's a form that means nothing. And that's a real shame because the landlord should have been a little more careful and actually just check mark that box. Or maybe the Association of Realtors could have actually just made it an opt out. But that's
Or
up to them to figure it out.
Or their agent. How about that? Their real estate agent. You can guarantee that any lease we do, which we don't do that many because it's a pain in the butt, but we do it for the right people. The lease has the box checked when it needs to be checked when it comes out of our office. And when I take a listing for a tenant occupied property, that's one of the first things I look at is to see whether they check the box on the AB 1482 exemption notice. And most of the time, they didn't, like you said. And again, free landlord forms from California Property Law Group. They have the exemption form there, and they explain the difference whether the renter was there July 2020 or before. It's a different process. After a different process, they explain it in their amazing paperwork there. You guys need that flow chart. Let's work on that flow chart for eviction. We'll get that there. All right, Joe Sixpack, how you doing, bud? Who enforces the attorney fee provision, though? Small claims court. Small claims court is a kangaroo court majority of the time. So, when would a landlord have to worry about that attorney fee provision?
So attorney fees are going to get added to whatever judgment is in play in the, let's say, eviction case or any case, really. So at the end of a case, you're going to have a judgment. And that judgment, then from that judgment, consequences can follow. So, for example, from an unlawful detainer judgment in the landlord's favor, the landlord can get a writ of possession and recover possession of the property. For the attorney fees, that's a sum of money that needs to be paid to somebody. That means that you can go get a writ of execution, which has instructions to the sheriff to go after the debtor's assets. And from there, you can prepare different sheriff forms to get the sheriff to do bank levy, garnish wages. You can record an abstract of judgment. So if they have any property in the county, you will have a lien automatically created against that property. So essentially, you don't have to go back to court. Once you have an award of attorney fees in your favor, you don't have to go back to court to confirm that amount. Instead, you go from the court to the sheriff to collect that amount. And then if there's some issue with the collections process, where do you go? You go back to court and you have another fight in court. Those are called claims of exemption. And there's a whole body of law around collection procedures. But generally speaking, you don't have to do any more lawsuits, and you just go and start working on the collections side of things.
So you can't expect the sheriffs to show up, guns drawn, helping you get your money. But that is, you do have to fill out the paperwork. I guess it depends on your relationship with the sheriff. All Nighter says documentation beats conversation. And I like to say that a verbal agreement is as good as the paper it's written on. So those are the same things right there. Well said, all nighter. Nick was asking, does the day you serve the 3-day pay or quit count as day one? No, it's the next day. That's day one, right?
Yeah,
Zach's nodding
you count as
aggressively.
it's day zero, if you will,
Yeah,
the day that you serve it.
that sounds like a horror movie. Day zero. I feel like I would watch that. Okay, so we got a couple other things we wanted to talk about. Kenny, you wanted to talk about security deposit questions. Is there anyone in particular? Real fast while you're composing your loquacious thoughts. Security deposits are capped now. So, for the most part, most landlords in California can only collect 1 month's rent for a security deposit. There are exemptions. If you have fewer than 2 properties that are cumulatively less than 4 units, then you can charge 2 months' rent. 3 months' rent, which was for a furnished unit, is gone, doesn't exist anymore. So, Kenny, tell me about security deposits. What are you seeing out there?
Yeah, so a couple things. You hit the pretty much the highlight parts where it's just going to be 1 month of security deposit. You can never go wrong with that realistically. And like you said before, if you are a small landlord, as in you have two residential properties and you're renting out 4 doors or less, you can qualify and get 2 months of security deposit. We had an interesting question posed to us in regards to, well, what happens if the lease agreement calls for different months of rent at different times? So depending on if it's the winter season or the spring season, which month of rent are you calculating the security deposit on? The security deposits law, or the statute, calls for it to be defined as the initial amount when the security deposit is first asked for. So
Hmm.
it's going to be based on the first month of rent that you're getting it on. So depending on what that first month of rent is, that's going to be the security deposit amount that you're actually calculating off of. So if for whatever reason, if your contract says that in winter the rates go up, or in spring the rates go down, it's going to be based upon the time that you are actually collecting the security deposit for, and that's the month that you're going to be collecting, or that's what you're going to be basing it off of.
That's good to know. That's a kind of a unique case, but there are plenty of longer, well, they're technically short term rentals or medium term rentals, but where there'd be different rental rates depending on the month. That's good to know. The security deposit, my favorite question for security deposits is, can I still collect first and last month's rent plus a security deposit? And the answer is no. Zach, go ahead. Lay into them for those
Yeah.
people
So,
wondering.
I mean, basically, you get um, once they changed the law regarding security deposits, basically everybody tried to come up with another name for the landlord holding on to money, um, basically to secure performance of the obligations of the tenant. So whether that's I don't know what you want to call it. I mean, it's a deposit or a gratuity or some kind of investment or whatever you want to call it. It's the same thing. You
Yeah.
can't be holding on to somebody else's money if it's in excess of 1 or 2 months, with an exception for if it's more than 6 months. Strangely, you can go nuts.
As
Um,
long as the term is 6 months or longer.
yeah,
'Cause that's what the law says. And you probably know the exact civil code, you goof. You'll think of it. It'll come to you. It'll
I
come to
should
you.
probably, but I can't go more than that. But yeah, I mean, so yeah, so don't try to get too cute with this.
Yeah.
Yeah, unfortunately, there just really aren't a lot of good ways to get around this law.
The
Yeah.
other big question, so they'll say, well, I'll collect 1 month's rent, but can I do a key deposit? Can I do a deposit for whatever? Can I charge a pet? No, it's 1 month, whatever you call it. That's it. And then don't try to charge a deposit for an emotional support animal. We won't go into that either.
Yeah,
They're not a pet. You can't charge a pet deposit.
and while we're on the topic of actually collecting security deposits,
Yeah.
starting in July of this year, you are required, if you want to actually deduct against a security deposit,
Yeah.
you are going to have to start taking pictures of the unit. Now, most of the time when you're listing out the
Three
unit, you'll
sets of pictures, Kenny.
presets, yeah. It's basically before the tenant moves in,
Yep.
right after the tenant vacates, and then right after any charges or fixes you've done to the unit. So, most of the time, the first set should be pretty straightforward. Usually when you're listing it, you have no one to stop you from taking pictures. And it's pretty clear that you should be taking pictures to list it. And then afterwards, when the tenant vacates, don't forget to take pictures or you're not going to be able to deduct anything from the security deposit. The law is very clear on that. And if you try to deduct against it and the tenant says, give me my money back, you're not going to have an option. Or you're going to have to be faced with a lawsuit if you try to deduct against it.
Yep.
So
Small
do your
claims.
homework, take pictures.
Yeah, small claims court. Here you come, and you're going to lose. There's two ways to lose instantly now with the security deposit deductions. One is to not have the 3 sets of pictures and give that with the itemized deduction to the renter. The other one that everybody forgets is to miss giving it back within 21 days. If you go to day 22 and returning security deposit, you've just lost your ability to do that. So you basically lose instantly any deductions. So fun to be a landlord. Frank, my tenant and I signed an agreement. He would park outside the building, and in return, I wouldn't evict him for a substantial remodel. This was after a long 10-month battle. Before we go to the next part of this, what's interesting, Frank, if you were in LA City and it was a JCO property, you couldn't even do a substantial remodel eviction. But we'll assume that's not the case. That your renter was eligible for a substantial remodel eviction. Now he's parking inside again, even though he signed the contract. He also has a handicap sign on his plate. What can I do? He's not respecting the agreement. Gentlemen, what do you think? It's a complicated one, huh?
Well, so it depends on, I guess, what form that agreement took. So Code of Civil Procedure 664.6 lets you have a court retain jurisdiction. So you can imagine that you have a lawsuit and you say, we've settled this lawsuit, we're done fighting. All that's left to do is they're going to pay me this money, they're going to move out, a bunch of things are going to happen. You can either have 664.6 or not. If you don't have 664.6, you can't go back to court and try to have the court enforce the terms of the agreement that you just made. So you just made an agreement, just like the rental agreement that you made with this person initially. If that agreement gets violated, what do you have to do? You have to file a lawsuit. So if you don't have 664.6, you would have to file another lawsuit about the previous lawsuit, right? Kind of crazy. So it's a good idea. It's sort of a trap for the unwary. If you have an agreement that's to end a lawsuit, you want to put into that agreement, typically, court to retain jurisdiction pursuant to 664.6. Put it in the written agreement or have the parties stipulate on the record orally. Either way, if you have that, you're in good shape. You could say, assuming that this isn't stale. I mean, if this agreement was made 30 years ago, I don't know that the court's going to really do anything at this point. But assuming that this was relatively recently and he violated the agreement, you can go back to court if you have 664.6 and say, Your Honor, he's violated the agreement. Now, what the consequences are going to be defined by the agreement. So maybe the consequences are he pays you more money. Maybe the consequences are he has to leave. That's going to depend on the agreement. But in principle, if you have 664.6, you can go back to court and it's quite easy. If you don't have 664.6, you have to file another lawsuit.
For those at home that are playing a drinking game with 664.6, you're now on the floor. Say it one more time, Zach. Don't get scared. Hold on. Go ahead.
Remember it. It will save you. Yeah.
One more time.
Hey,
do it one more time.
664.6. Cheers.
Yeah. I love that about you. We're allowed to have fun with civil code, right? That's fun. So Nick wants to know, do we need more than one way to serve the 3-day pay or quit? So the order of priority for serving a 3-day pay or quit, number one, the best way to do it is hand it to the renter. Number two is substituted service, handing it to somebody at the place where they live that's 18 or over. Number three would be posting and mailing. So you're going to hang it somewhere, they're going to find it, and you're going to mail it. Gentlemen?
You got it right on the head.
Yeah, and then you can hire a process server to do it like these guys do for the summons and other important paperwork. You can hire a process server to do it. So, okay, more questions coming in.
Service is always a fun topic because there are questions about like, can you be served at a McDonald's? Can you get served at a bank? I was like protected because I was in like an airplane or you can't catch me. But the personal service, if you can get it to them directly wherever they are, that's considered proper service.
So, Free Builder has a good point. 1 month's rent as security deposit is easily confused as last month's rent. There's a new regulation with a built-in problem. So you're right, and that's actually why the California Association of Realtors lease and some other leases will specifically say that the security deposit cannot be used as last month's rent. So I'd recommend making sure that's in there. And then as you're getting close to the end of the lease, make sure the renter understands that. Because there won't be any money left over in the event that you need to deduct. All Nighter's going to be sharing this with his real estate investment school community. We appreciate that. It's true. All right, let's see. Okay, so we're running out of time. I'm having fun, and I don't even know if we're going to get any more chances to talk about 664.6. But let's talk about LA City is considering capping rents for rent stabilized properties. They're actually talking about it today. What gives, guys? Like there was a 4-year break. They weren't able to raise rents at all for 4 years due to COVID. And then it was a small increase. And they're talking about only allowing like 3% next year. Like what is this new cap they're talking about, Kenny?
Yeah, so LA City, it's the committee, the homelessness committee. So it's not actually in front of the entire LA City Council chambers yet, but they're taking suggestions and public comments in regards to lowering the floor as well as the ceiling on currently rent controlled units. So what some of the proposals that they have ongoing right now would mean that 4% that you were able to raise the rents on rent controlled units. They want the floor every year because it's calculated every year. They want it to go down to potentially 2% and maybe a cap of 5%. And that's going to be following the CPI minus shelter, a different version of a CPI calculation. And on top of that, there are some landlords who have enjoyed the idea of raising a rent by 1% for every utility that they've been paying on top of that. They're also considering removing that. So if you've been paying utilities for the building itself, you no longer would be able to raise that 1% or get that 1%. This is not something that has happened yet. This is the LA City trying to address what they believe would help the homelessness situation. But that's what they're looking to do. And in the event that it goes further, you might see something on the LA City Chamber's minutes in the next couple months or so on that.
So just to clarify, that we're going to use the CPI minus the shelter index, so minus the very thing that they're supposed to be using to calculate the rent. So we're going to take that out. And anyway,
These are just suggestions and
Yeah.
proposals. Leave it to them to figure out if it makes sense.
Yeah, well, it doesn't matter if it makes sense. They're still going to vote on it one way or the other. So, and you just mentioned helping with homelessness, and it is a very serious problem. The unhoused, that's a very serious problem in Los Angeles. There's a lot of money devoted to helping that situation in Los Angeles. And unfortunately, it's not getting to the renters. They do have the right-to-counsel ordinance, which we really didn't get a chance to talk about much, but that is where renters, if they receive an unlawful detainer, can get a free attorney to help with that, even if they legitimately are behind on rent, for example. But another way to potentially help the unhoused and help reduce rents would be to maybe build some more housing. Is that a crazy thought? Am I going out on a limb on such a thing? What do you think of that, guys?
Well, it's always been kind of more or less a local fight versus a state fight versus a federal fight kind of thing. Every jurisdiction has their own beliefs in terms of what they believe is going to fix the situation. But one of the things that can always guarantee is that every level of government will be fighting every level of government. And that seems to be the story here. Recently, the California State Legislature passed SB 79, which basically allows for the states to override local jurisdictions' zoning laws in relation to transport oriented developments. So this would be in relation towards
Bus lines, trains,
bus line, subways.
transit orient, where you can easily walk to public transportation, particularly the areas of the densest public transportation.
Yeah, and what they're looking to do, at least what the state level is looking to do, is to incentivize developers, investors to start building more dense housing around those transit-oriented developments. As far as I'm aware, this bill is currently sitting with Gavin Newsom right now, who may end up signing it into law. And I do know that the LA City Council voted against it, which is the reason why I said that, every level of government will be fighting each other on this issue.
Yeah.
Um,
I just pulled up a good discussion about it. And Kenny, thank you for sharing this with me before we came on. Kenny wanted to share this. He was afraid it was too political. And I don't think the idea of creating more housing for our citizens should be a political issue at all. It should be an obvious thing, and politicians on either side of the aisle should stop wasting their bleeping time on other stuff. So sorry, I get a little passionate about it. You can see the units permitted. This is from CaliforniaYimby.org. Yimby is yes in my backyard, not NIMBY, which is no in my backyard, which is what's been going on. So this shows you the number of units that have been permitted, and not enough. This article has a great coverage of what this legislation would mean, shows where taller buildings can be built and more units can come to Los Angeles and help fix the problem of the unhoused and actually make a difference. Okay, sorry, I got a little heated. I get so annoyed. Like, that's the solution. Quit trying to throw money at stuff that doesn't work and taking rights away from people. Build them houses. I mean, I'm such a hippie. I know. So we're
I
running
mean, I mean,
out
a,
of.
a lot of this does kind of dovetail somewhat into the rent control issues as well, and what LA City
Yeah.
is doing, because they're realistically what they're fighting over is a 1% decrease, right, from a 3% floor to a
Yes.
2%. And if you do the math for many of these units, a 1% differential, you're talking about potentially for, let's say, like a $3,000 unit, that's a $30 difference per month. If you're talking about a $1,000 unit, that's $10. And I don't really know if that's going to change the pricing of just residential units or just buying housing in general in LA, when we're talking about, let's try to move the needle on $10 when we could start building more housing.
What it is it's taking an orange and squeezing it to try to get every bit of juice out of it instead of going out and buying more oranges or making more oranges. That's all it is. So you're spot on with that. If you want to lower rents, don't force people to charge lower rent. You fix it with the market by bringing more houses to the market, and it'll fix itself. Uh, Again, don't bring this stuff up. I just get angry, Kenny. I get angry. Look at this. No, I appreciate you talking about this. And speaking of you guys, and just number one, donating your time to answer these questions and be here and dive in and explain these things. I'm not paying you for this. I appreciate you guys doing this. Tell me more about why we, if we're landlords, should hire California Property Law Group. What makes you guys different? We're going to start with Zach and we're going to go to Kenny. What makes you different, Zach?
Yeah, so we have been fortunate enough to help thousands of people recover possession of their units. We're really on top of the latest changes. You can always reach us by phone or by email. And yeah, I think that we do a great job helping regular people navigate what are really crazy, complex, and constantly changing laws. Yeah.
You guys do. You guys are absolutely on the cutting edge. Your boots on the ground, I always like to say, because you're actually in the courtrooms, and then you're tracking this stuff. Kenny's the one who brought it up to me that the Homeless Council is meeting to discuss the change in the RSO rent limits. So Kenny and the whole team there is tracking that stuff. It's amazing, as busy as you guys are, that you can do that. Quick, before we go to you, Kenny. So our single family landlords required to abide by this rent increase that we discussed? No. Costa Hawkins protects and exempts single family homes. That's what Prop 33 was trying to eliminate, were the protections for single family homes. We still have protections. Those are exempt from rent stabilization, but there's other things that are subject to we won't go into. Kenny, why the heck should I hire you?
So throughout the entire process, I've been kind of stressing at, evictions and unlawful interactions. They can be very stressful times, and I would hate for something to go wrong only because of a procedural defect or a technical defect. Again, one of my best quotes that I've ever heard from a client was, if you lose with another attorney on a technical defect, it's not as if I lost on a technical defect. And again, in my opinion, losing on a technical defect is the same thing as losing. With us, we are always looking to see what the law actually says, so that you avoid those technical issues, and we take care of that for you. And essentially, we want the process to actually merit or to reflect what we thought the justice system should look like, which is what is actually going on here, what is the merits of the case. And we always get to that position where we're able to talk about what actually matters to the litigants, what actually matters to the parties here, and we look to reach a resolution that actually makes sense. Because unfortunately, there are many, many cases out there where it's not their second eviction, it's not their third eviction, it's not their fourth eviction. They're on their fifth or sixth, and it's the same unit, the same parties, and they've been doing it for 2-3 years. And most of the time, they're talking about procedural defects because whoever they hired didn't know that you were supposed to put the number of the bedrooms on the notice, didn't know you were supposed to mail it on a specific date, didn't know you weren't supposed to accept rent during the lawsuits, things like that. We got you through all of that, and we answer any of the questions that you have to make sure that you don't fall trapped to that.
Well said. If you want to save money and time, ultimately, what you do is you hire professionals like these. I know some people are afraid, oh, it's too expensive to hire an attorney. There's nothing more expensive than hiring a non-professional or trying to navigate through a professional's world, especially when LA is handing out attorneys to renters for free. You don't want to be behind the 8 ball. All right. Well, thanks, guys. We're over an hour. I appreciate you. Happy holidays to you, Zach. I don't know the appropriate thing to
Easy
say. I
fast.
apologize.
Easy fast.
Easy fast, my friend. Easy fast. My apologies. Kenny, good to see you. Looking forward to seeing you guys again soon. Thanks for getting me all worked up, Kenny, about housing in
I
LA.
didn't mean to.
Way to go.
It's only a suggestion that what they're doing.
Yeah. Well, thank you. Appreciate you guys.